At this point, the adoption of the C63 pre-study budget in the amount of $23,250. I understand that budget has been previously distributed to all members. Can I see a show of hands in support? That's unanimous. Thank you. Adopted. Pursuant to Standing Order 108 Sub 2 and the motion adopted on December 2nd, 2024, the committee is meeting in public to begin its study on the subject matter of Bill C-63, an act to enact the Online Harms Act, to amend the Criminal Code, the Canadian Human Rights Act, and an act respecting the mandatory reporting of Internet child pornography by persons who provide an Internet service, and to make consequential and related amendments to other acts. Now, at this juncture, I'd like to welcome our witnesses for the first hour. Appearing on behalf of the Quebec Bar, President Catherine Claveau, representing the Secretariat of the Order and Legal Affairs, Nicholas Legrand-Allery, a member of the Criminal Law Expert Group, Michelle Marchand, and appearing in person, Madame Anne Brussiere-McNichol, Director of the Fundamental Freedoms Program. Witnesses, please wait, and members, please wait until I recognize you by name before speaking. For those participating by video conference, ensure you have selected the language of your choice for simultaneous interpretation on the bottom left of your screen, and please mute yourself when you are not speaking. I remind all members to take the floor only after being recognized by the chair. Without any further delay, the floor is yours, each witness for 5 minutes. Who would like to start? Perhaps Madame Brussiere-McNichol. Oui.
Bon après-midi aux distingués membres du comité. Je vous remercie.
Good afternoon to the distinguished committee members. Thank you for this opportunity to share the Canadian Civil Liberty Association's perspective on Bill C-63. The CCLA is a national independent non-governmental organization founded in 1964 with a mandate to defend and promote the civil liberties, human rights, and democratic freedoms of all people across Canada. At the heart of our mandate is the fight for strong protection of freedom of expression, privacy, and the principles of fundamental justice. The CCLA recognizes the importance of legislative initiatives to protect some of the most vulnerable members of our society from particularly harmful forms of online speech. In this sense, the CCLA recognizes that some of the specific obligations created by Part 1 of Bill C-63 for operators of regulated services are welcome. However, the current draft of the Online Harms Act also includes more general statutory obligations that need to be clarified and appropriately limited, failing which they will raise issues of freedom of expression and other matters. For example, the general duty to implement adequate measures to mitigate the risk that users of the service being exposed to harmful content is decidedly vague in scope. In the absence of adequate safeguards, operators are likely to attempt to comply with this imprecise obligation as efficiently and economically as possible. This could be done at the expense of users' freedom of expression, for example, through proactive content monitoring, which is not at this stage prohibited by the Act, or through content deletions based on non-transparent algorithmic analyses. The general duty imposed on operators to implement tools and processes to flag harmful content under Section 59 suffers from similar shortcomings, also likely to jeopardize freedom of expression. For example, the Act as drafted would allow operators to remove several categories of reported content without giving the author the opportunity to present his or her point of view. In fact, for several categories of content, the Act as drafted even implicitly allows operators to remove reported content without first determining whether it actually qualifies as harmful content. These issues can be mitigated through recommendations 1 to 3 of our written submissions. We suggest that operators be required to fulfill their statutory obligations without engaging in mass surveillance or unduly limiting their users' freedom of expression. We also recommend that the new Canadian Digital Security Commission be required to ensure on an annual basis that operators are indeed complying with their obligations in relation to users' rights. With regard to Parts 2 and 3 of the bill, the CCLA welcomes the recent announcement by the Minister of Justice that he wishes to separate them from the current process. In so doing, the Minister of Justice is acceding to a request made several months ago by the CCLA and several civil society organizations to ensure that this committee's study of Part 1 is not overshadowed by controversial changes to the Criminal Code and the Canadian Human Rights Act. The CCLA believes that Parts 2 and 3 of the bill should not be passed by Parliament. With regard to amendments to the Criminal Code, the new hate-motivated offence would irrationally increase the maximum penalty associated with any offence in Canada up to life imprisonment if the commission of such an offence is motivated by hate. This vast judicial discretion paves the way for disproportionate sentences, increased plea bargaining by innocent, vulnerable defendants, while limiting freedom of expression in Canada. The CCLA also opposes the new fear of a hate propaganda offence or a hate crime provision. Criminal law should be a means of holding individuals accountable for actions they have taken, but not for actions that others fear they may take in the future. Allowing a judge to limit the freedom and expression of individuals who are not even suspected or accused of committing a crime, let alone convicted, unreasonably and unjustifiably infringes on many charter rights. Finally, as for the suggested amendments to the Canadian Human Rights Act and Part 3 of the bill, they would be inappropriate and ineffective in addressing the issue of hate speech in our modern society. These amendments would flood human rights organizations already suffering from a chronic lack of resources. Thank you for your attention, and I'd be happy to answer any questions.
Beaucoup.
Thank you very much.
Next, Madame Claveau.
Ms. Claveau, you have 5 minutes. Thank you, Chair and members of the committee. I am Catherine Claveau, President of the Quebec Bar, and with me today are Michel Marchand, a member of the Criminal Law Expert Group, and Mr. Nicolas Legrand-Allary, a lawyer with the Secrétariat de l'Ordre des Affaires Juridiques du Barreau du Québec. Thank you for inviting us to testify on Bill C-63. Based on our experience in criminal and human rights law, we are commenting only on Parts 2 and 3 of the bill, that is to say, the proposed amendments to the Criminal Code and the Canadian Human Rights Act. Let us begin with Part 2 of the bill, that is to say, the amendments to the Criminal Code. Given the marked increase in hate crimes, the majority of which are based on race and ethnic origin, it is essential that the bill provide the courts with effective tools to combat them while ensuring that they respect the principles of fundamental justice and Canadian constitutional requirements. For this reason, the Quebec Bar supports the Quebec Minister of Justice's request that the legislature remove the religious exemption for hate propaganda from the Criminal Code. We are also of the opinion that it is essential to codify a definition of hate. On the one hand, this will encourage reporting by giving communities a clear understanding of what is prohibited, and on the other, it will help all stakeholders, including the police, to act within well-defined rules. However, we do have reservations about the bill's definition of hate, which is inspired by the Watcott decision. In that case, the Supreme Court of Canada ruled on the constitutionality of a provision prohibiting hate literature in a human rights context. We submit that in criminal matters, the key decision is the 1990 Keekstra decision, the analysis of which was repeated again in the 2005 Mugesera decision. In these decisions, the Supreme Court interpreted the notion of hate with specific reference to the provisions of the Criminal Code, finding that it designates an emotion that is both intense and extreme and that is clearly associated with calumny and detestation. To avoid the risk of a constitutional challenge to this provision, given that the burden of proof in criminal law differs from that applicable in civil law, and that the Canadian Charter of Rights and Freedoms offers guarantees to the accused in criminal matters, we suggest that the bill adopt the latter definition. The bill would also make it a hate crime to commit an offense under the Criminal Code or any other federal statute motivated by hatred based on certain factors. This new offense would be punishable by life imprisonment. Referring to any act of Parliament, the scope of this new provision is broad and risks covering a very wide range of offenses without any distinction being made as to the objective seriousness of each of these offenses. This new provision is contrary to the fundamental principle of proportionality of punishment set out in Section 718.1 of the Criminal Code. We therefore propose to improve the existing provisions of the Criminal Code, thus avoiding the creation of a new hate crime prosecution regime that would coexist with the current one that we already have. Let's move on now to Part 3 of the bill, the amendments to the Canadian Human Rights Act. First, we welcome the reinstatement of Section 13 of the Act, which deals with the communication of hate speech. We note that the proposed new wording is more precise and better circumscribed, which will strike a better balance between the rights and freedoms protected by the Canadian Charter. We also support the definition of hate speech proposed in the bill, which respects what the Supreme Court stated in the Watt Court decision rendered in a human rights context. Finally, the bill introduces a punitive aspect to the Canadian Human Rights Act, which we actually question. The Supreme Court wrote, notably in Taylor and Blanco, that the purpose of the law is not to punish wrongdoing, but to prevent discrimination, and that human rights regimes must aim at conciliation and not punishment. In the form proposed by the bill, this would be a punitive measure that would distort the very purpose of any human rights regimes. We suggest that the penalty be paid to the victim, or if the victim cannot be identified, that it be paid to an organization dedicated to defending the rights of the person or group targeted in the communication constituting the discriminatory act. Following the example of Section 53.3 of the Canadian Human Rights Act, a provision could also be made for ordering the perpetrator of the discriminatory act to pay special compensation to the victim if that act was deliberate or reckless. Other comments can be found in our brief, and we are now available to answer your questions. Thank you.
Merci, Madame Claveau.
Thank you, Ms. Claveau.
Next, Monsieur Legrand-Allery, 5 minutes.
Oui, Maître Legrand-Allery est à...
Mr. Legrand-Allery is with me. He is not making a statement.
Merci.
Thank you.
5 minutes.
C'est la même chose. Maître Marchand et...
The same applies to Mr. Marchand, Chair. He is with me.
Okay. Witness number 1, 5 minutes, please.
Hello and good afternoon. Thank you for your time today. I am Jane. Perhaps like I do, many of you as well hold the same title, the title of parent. I am a mother of a once spirited young girl who has been sexually abused and on account of the abuse has also become a victim of sexual exploitation. Maybe you yourself as a parent can relate to my child's story, which unfortunately has also become our family's lived experience. With my few allotted minutes, I'd like to provide some insight and perhaps describe a few details of the horrific sexual abuse my little girl has endured and continues to endure daily. My daughter was just a toddler when one day fate stamped itself upon her. Just a young child that had no choice but to solely entrust her life to the hands of an adult who was supposed to protect her from harm, teach her right from wrong, and love her in such a manner that cultivated and enforced a future of what a healthy relationship was supposed to look like. In her preschool to kindergarten years, she was groomed to believe that sex or sexual actions between children and grown-ups was completely acceptable and normal. Some days, instead of watching cartoons, she would spend her time with a presumably trusted adult who normalized child pornographic material. This normalization took place by subjecting her to possibly hundreds of child exploitation videos repeatedly at any opportune moment. With the help of various child sexual abuse material, she was conveniently raped by her abuser over and over again. Based on evidence collected by law enforcement, it could possibly be determined that she was raped and sexually assaulted on a daily basis. She was between the ages of anywhere from 3 to 6 years old, raped in such a way that she was brainwashed to believe it was a fun game. Many times she was bribed with candy as her reward for performance. Her performance included, but is not limited to, oral sex, vaginal intercourse, and edged on to insert various items into her anus. The perpetrator was her biological father. This man also trafficked his own daughter by having her virtually participate in scripted sexually explicit activities with one or more adults within the dark walls of the online world. When my child's abuser was caught, he admitted the abuse had spiraled out of control. He had become desensitized to raping my daughter for his own sexual satisfaction. He admitted to law enforcement that he was always hungry for more. My child's understanding of what happened to them is greater than they wish they could remember. The extent of the damage that was done to her in the moment and that continues in the present is incalculable. My little girl has countless flashbacks that haunt her while she sleeps. Often she is anxious, fearful, and scared. Sadly, the abuse that happened to her is in hyperactive state and is known as one of the top downloaded series of child sexual abuse material that is circulating on the dark web. Child predators have saved and shared images and videos of her tiny body lying naked and contorted in provocative ways. Her privates are no longer private. Her vagina is on display for the world to view. Her smile, her laughter, and her innocence have all been taken from her. How she is portrayed in those pictures and the videos is not how she wants to be perceived. Those who take it upon themselves to download, view, save, and share my child's inappropriate pedophilia merchandise take part in continually harming her. Perpetrators have blatantly premeditated their motives and have activated those actions against her will. Individuals that possess her child sexual abuse products, no doubt, should be held accountable and should take full moral responsibility for their own contribution of the continued exploitation crisis my child and many others continue to endure. Because of these perpetrators' antics, my child has secluded herself from enjoyment of a fulfilled life. This is the only coping mechanism she believes that she has to protect herself. She tries to hide herself by not leaving the house. If she does, she fears she may be recognized. She feels that she is damaged beyond repair. She wants the memories to vanish. Until the internet has mandatory regulations and rules that aim to protect her and other victims against child sexual abuse material, the images will continue to exist. The evolution of technology has been her nemesis. As of now, she cannot escape the abuse, nor can the abuse escape her. I will fight for my child and be an advocate for the protection she deserves. This should not be a debate. My child has suffered in silence for far too long. She should not be ashamed, neither should she feel guilty of the personal attack that takes place on the uncontrolled internet. Allow her and others to find their dignity again. Moving forward, we have a choice to be the change and the shape the future of all children. My little girl is not solely a victim of hands-on offending. She is re-victimized every single time her child sexual abuse material surfs throughout the dark web. What kind of person doesn't want to protect the future of our children or grandchildren? I will say it again with urgency. We need a culture of lawfulness that strongly enforces internet regulation. The unregulated internet has damaged my child and countless children across the nation.
Thank you, witness number one. I now recognize Mr. Van Popta. Sir, you have 6 minutes.
Good. Thank you. Thank you, Mr. Chair. And thank you to all the witnesses. And Jane, thank you for your very courageous statement. But before I get into questions to the witnesses, I would just like to read a motion into the record, notice of motion, which reads, given that a need exists to quickly pass provisions to keep Canadians safe while protecting free speech, members of several political parties have expressed a need to split Bill C-63 in part due to reservations about the bill's provisions involving restrictions on speech. The Justice Committee is currently doing a pre-study on Bill C-63, and Bill C-63 proposes giving full responsibility to develop regulations for online platforms to a regulator that hasn't been formed yet, and does so with too much ambiguity on what regulations this body will propose to or administer. And finally, that based on witness testimony, a better approach to keep Canadians safe online while protecting their civil liberties would be to legislate a defined list of responsibilities that online platforms have to undertake to keep Canadians safe. Therefore, that the committee proceed to concurrently pre-study Bill C-412, Promotion of Safety to the Digital in the Digital Age Act, along with its pre-study of Bill C-63, so as to examine other legislative options to protect Canadians online, which could be quickly advanced by consensus without the controversial elements of C-63. That's the motion, Mr. Chair.
Mr. Van Popte, you are only giving notice at this point. You're not moving. Is that correct?
Just giving notice of it, that's right.
Thank you.
Yeah.
You have about 4.5 minutes left.
Okay, good. Well, thank you so much. So, Ms. McNichol, I have a question for you. This is a study on Bill C-63, and I know you're very well versed on the topic from your testimony and also from what I read about what your organization has said. But before I ask you a question on it, I want your opinion on this Bill C-412, which I just mentioned in this motion. It's a private member's bill by a Conservative member of Parliament, our colleague Michelle Rempel-Garner, and it deals with some of the same issues. Its subject matter is Bill C-63. So I'll just give it very high level. C-412 will modernize the existing crime of sexual harassment to deal with online harassment. It will require social media platforms to increase safeguards for children around bullying, sexual violence, self-harm, sexual abuse material, as witness Jane has mentioned. And it will update Canada's existing laws around distribution of non-consensual, artificially produced images, deepfakes, in other words. Bill C-63 does not address any of those topics. So there's a big gap there that we think C-412 will fill. So here's my question. Would you agree that these are important subject matters that should be discussed on a priority basis, an opportunity that is presented by Bill C-412?
Merci pour votre question. C'est évident.
Thank you for the question. Obviously, to be able to give you a detailed response or a proper response, I would need to look at it more closely. I have had an opportunity to take a look at it. I agree with the suggestions regarding harmful content and the fact that it's problematic. With respect to Bill C-412, perhaps less issues regarding freedom of expression are at stake, but there's also the issue of the respect of privacy and legality. Much of this bill refers back to parental control of content when it comes to what minors can read. And when you're talking about parental control, you have to know that current methods of verifying the age of a child is imperfect. And these techniques have to be more effective, and they mustn't discriminate against people based on their ethnicity, as well as when information is being collected. That information has to be also respectful of privacy in Canada.
Understood. So I'm happy that you have some familiarity with Bill C-412. In your opinion, could they be studied at the same time, Bill C-412 and this Bill C-63?
Ça relève pas de ma compétence, à moi de répondre à cette question-là, je crois.
Fair enough. I noticed in your testimony 1, 2, and 3, and you're happy that parts 2 and 3 have now been removed, and I know your organization recommended that, so the minister listened to your recommendation. Congratulations. But my question is whether part 4 of C-63 could be separated out completely and dealt with separately to accelerate the protection that it would afford to people who are sexually harassed. Part 4, just for your reference, it amends an act respecting the mandatory reporting of Internet child pornography by persons who provide an Internet service. Part 1, on the other hand, creates a regulatory body which is going to be time-consuming expensive to get there. Part 4, if it was separated out completely, could be dealt with very quickly. What's your opinion on that?
Je dirais que la partie 4, certainement, soulève moins.
I would say that, yes, Part 4 does raise more issues. On the other hand, Part 1 is very important as well, and civilian society has taken a lot of time to think about it. Several organizations, including my own, are willing to take a position on that part.
You have 9 seconds.
9 seconds. I can't do anything good in 9 seconds. Thank you, Madam McNichol, for your testimony.
Thank you, Mr. Van Popta. Moving on to Mr. Mendocino. You have 6 minutes, sir. Madame Brière, 6 minutes.
Thank you. Thank you, Mr. Chair. Do you hear me well? So, merci, Madame Jane, pour votre témoignage.
There's no translation coming through. And there's some issues, Madame Brière, there's some issues with your headset.
OK. Pourtant, on a fait tantôt les tests de son et ça allait.
Yeah, this sounds not. Can we try again? Maybe we can suspend and try and figure it out, or do you want to move to someone else?
Can you move to somebody else? We don't have time to suspend.
Try calling her.
Would that be you, James? Okay. Madame Brière, we are going to, we're not going to suspend. We'll have the technicians give you a call to sort out your headphone issues. In the meantime, I'm going to turn matters over to Mr. Maloney. Mr. Maloney, there's roughly 5.5 minutes left.
Thank you, Chair. Witnesses for joining us today. Jane, I'll refer to you that way. Thank you very much for sharing your story, your horrific story with us. We're here talking about a bill the government presented, Bill C-63, particularly Part 1. My question to you is, and you addressed this somewhat because I think, if I quote you, said, the unregulated internet has damaged my child and continues to do so on an ongoing basis. One of the important parts of Part 1 of the bill, which is the part we're focusing on, is the so-called takedown provisions that would be required on the internet. Criminal code provisions are one thing, but there's a requirement, as you alluded to, about the importance of having the ability to instantly address a problem when it arises and have something removed from the internet ASAP. Can you expand on the importance of that in your view? And if this is not passed into legislation now, can you explain what impact that might have on your family and others?
So by implementing the immediate takedown, that's definitely the biggest part of solving this problem. Without having that in place, there's no end to this.
Thank you. So having lived through this, and I take it that included dealing with the police and the authorities, was there any immediate action taken to have the content removed from the online world? And if so, please share your experience in that regard.
My experience, this has been a very slow and drawn out process. Horrifically painful.
Completely ineffective. Okay, so what do you say to those then who are openly critical of these provisions of the bill and who have stated unequivocally that should this bill be passed, that they would remove those parts of the legislation, in fact, remove the bill altogether?
This part of the bill is one of the most important parts, protecting the children. Like, this is the beginning of the end of it.
Thank you. I'm going to move on to you, Ms. McNichol, because in your opening remarks and in your answer to some of these questions, you spoke about parts 2 and 3, which we're not talking about right now, but you did say part 1 is important and you're willing to take a position. What is your position on part 1, particularly in light of what you just heard from Jane?
Absolument. Donc, je crois avoir compris que l'obligation...
I believe what I've understood refers to Section 67 and the following sections, and that's when there is content that is very harmful, content that sexualizes children. And there are delays in reporting and removing content when it is true. The CCLA does not have any issue with the provisions regarding that. Our issues are more with the more general statutory obligations. For example, sections 55 and 59. Under section 55, there's a general duty to take reasonable steps to make sure users aren't exposed to harmful content. But unfortunately, without parameters, then an operator might be able to take a more like of a cautious approach, and that could limit freedom of expression unreasonably in Canada. For example, by looking proactively for content and deleting it. That would be a problem. But in the bill as it exists, that the operator could eliminate content without necessarily reviewing it, and we think that would be problematic. So we're not saying freedom of expression is absolute and there shouldn't be any reasonable limits on it, but one has to make sure that the statutory duties imposed on operators are prescribed to allow them to understand what those duties are and to understand what it is they have to honor in a reasonable way that is balanced with freedom of expression.
Considering to have a takedown provision in the legislation than leave it to the criminal law, and certainly than leaving it to the internet providers themselves. Wouldn't you agree with that?
Ben, je sais pas si c'est préférable. Je pense que
I don't know if it's preferable. I think both mechanisms have to be available. But once again, I do not object to the provision that allows for takedown in the meaning of what Jane Doe was suggesting. And I would just like to say that I fully understand the concerns of that witness.
Monsieur Fortin, tu as 6 minutes.
Mr. Fortin, you have 6 minutes. Thank you very much, Chair. I just wanted to thank all the witnesses for having come here today. And I also want to express my deepest sympathy for witness number 1 and for her testimony regarding the abuse that her baby, I would say, not just her daughter, but her baby, was subject to. I find it deeply, deeply troubling that this kind of behavior can continue. And I feel that we have to do all in our power in order to prevent these events from happening. That being said, Ms. Claveau, thank you very much for having come here today. And I have two questions that I would like to ask you about your opening remarks. You said that the bar supports Quebec's request to withdraw the 2 provisions from the bill regarding religious exemptions. We've often been told when we deal with this issue, that is to say a religious exception, that it is a clause or provision that hasn't been used very often, and that therefore perhaps the best thing to do is to remove it. But my question is this. Is it possible, even though this hasn't been alleged yet by the courts or dealt with by the courts, is it possible to imagine that it might be taken into account when one is bringing proceedings or not in a file? Well, yes, that's what we feel. And I think what's important to acknowledge is that unfortunately, there is hate propaganda, and it's increasing. And anything with respect to a religion will also increase along with it. So one of the solutions we think would help remedy this plague, basically, is to remove that religious exemption. I have another question for you with respect to the definition of hate. It's very difficult, perhaps even impossible, to define it clearly and to have a definition that everyone might agree on. This is always a very sensitive issue, and obviously the Supreme Court has said much about that. And the definition you were referring to in the Keekstra ruling is this, that it designates an intense and extreme emotion that is clearly associated with calumny and detestation. Now, calumny and detestation are perhaps easy to define. However, one day a judge is going to have to decide whether the accused was in the grips of an intense emotion, so intense and extreme that it's not just any emotion. Now, I don't want to imagine things. However, it might lead to surprisingly inconsistent decisions and rulings. I don't have an alternative to suggest, but I would respect the wisdom of the justices of the Supreme Court. And I'd like to know your opinion on this. To what extent should we be cautious when we're attempting to define something as subjective as hate, and to decide whether someone is in the grips of an intense emotion or not, and to what degree that emotion is intense? Well, thank you for the question. I think I'll allow my colleagues to respond because they're a little more familiar with the interpretations of the Supreme Court. Thank you, Ms. Claveau. I think you're right. We feel that definition of hatred will be difficult, but the idea is, or the purpose is to make sure that we respect the criteria or requirements that have been set out in Supreme Court rulings, and in order to avoid, to the greatest extent, any challenges or appeals. And I'll let Maître Marchand follow up on that, on the more technical aspect of definitions generally. Thank you, and good evening. To answer the question, I would say this. We're talking about an extreme and intense emotion, but that is an objective criteria because it all exists in the rulings, the Keekstra and Mugesera rulings. And you can draw parallels as well with other human rights rulings, for example, the Watcott ruling, where there was a decision to reformulate that criteria. And there was a criteria that ended up being adopted within the Mugesera ruling. So it was simply adjusted and refined. So basically what it says, you have to put yourself in the shoes of a reasonable person. You're not putting yourselves in the shoes of the person under the emotion. So it's the receiver, basically. So I believe that the definitions of the Supreme Court are clear. They have to be basically put together and included in the criminal code. And in C-63, I think what's in Bill C-63 is inferior to what was in the Mugesera ruling. We're talking about freedom of expression and freedom of religion, and people have rights. And the Supreme Court has analyzed this in great depth and have written hundreds of pages in its conclusions. So I feel that they've regarded this very seriously, and they have spent a lot of time trying to draw that line. I'm not sure if that answers your question.
That's your time.
Thank you, Mr. Chair. And I wanted to say to you, Jane, I've been in Parliament for many years. This is one of the most moving presentations I've seen from a witness. I know it would have been extremely difficult for you to come forward to this committee, and we can't thank you enough for the brutal honesty of what your daughter has been through. Is something that I think will remain in our minds for some time to come. Well, thank you for sharing that. All of us hope that your daughter is getting the care and supports that she needs. I wanted to ask whether the fact that these images are continuing to circulate obviously shows the importance of moving forward as quickly as possible with the provisions of the bill in Part 1 that deal with criminal sexual exploitation of children. But is it, at this point, is it individuals, is it companies? Who is continuing to perpetuate these terrible images of a crime?
So anyone that's accessing, I guess, the dark walls of the web, you know, child predators, people that are interested in that kind of stuff are the ones that are, you know, trading these images and uploading them on a regular basis, you know, pretty much daily.
And doing it with impunity.
Unfortunately.
So you're...
And, you know, not only the images, but there's regular talk about my child.
Yeah, I just can't imagine as a parent what you're going through and what she's going through, and
It's a very scary situation.
yeah, and the message you're sending us is very clear, that we need to take action. I think all members of the committee understand that, and I can't thank you enough for coming forward today to share that with us. I have questions for the other witnesses. Je voulais faire un suivi avec Madame Bussière-Nicol.
I'd like to follow up with Ms. Bussière-Nicol and also with Ms. Claveau. So when you look at Part 1 of the bill, there's a reference to penalties. And for a company, the maximum would be $10 million or equal or more than 3%. Also, summary conviction can be $5 million or the 2% or more. But in the case of an individual, there would be a maximum penalty of $50,000. It strikes me as being very little when you consider the impact for families like Jane's family and her daughter. So what do you think about the penalties? It's one thing to have a framework in place. It's another thing to establish penalties that will stem this plague. And obviously, in cases like, for cases like the child of Jane, we need to take very significant steps. So what do you think about that approach in the bill? And I'll start with you, Ms. Bussière-Nicol. Thank you for the question. What I would say is that it's important to put the harmful content in perspective. When you're thinking of penalties for individuals, it's very important to not be so excessive that those individuals might be penalized other ways. And in terms of the operators, though, I mean, if they want to speak to the penalties, they can. But one important issue to think about is that the higher the penalties, the clearer the duties have to be, because if they're not, then the operators, if they're clear, are going to want to respect the duties, but they may go overboard. If those penalties are extremely high, they may go overboard and take more of a cautious approach, and they may actually go above and beyond and actually exaggerate in how they are dealing with that content, and that could be harmful in itself, it could be harmful to freedom of expression. I see. So your concern is with the definitions then and the directions that are provided in the bill. I see. Thank you. That clarifies it for me. Ms. Claveau, I'd like to ask you the same question with respect to the penalties and the way Part 1 is structured. I think it's clear to everyone that we need this, but what do you think about the approach that is being taken in Part 1? I'm going to give the floor to Maître Legland. Thank you. As you've seen, we haven't had specific comments to give you on Part 1. However, generally speaking, when we look at the penalties, especially in terms of administrative monetary penalties, there is a structure that allows to determine the amount, whether it has to do with individuals or businesses. Sometimes it's a percentage, for example. All these things have to be considered, and without necessarily taking position on this, it is work that has to be done. I would actually suggest that you look at this closely and you look at how it compares to other systems and even Supreme Court rulings.
First round. We are now moving into the second round. This will be the final round for the first panel. 15 minutes, 5, 5, 2.5, 2.5, starting with you, Ms. Ferreri. You have 5 minutes.
Thank you, Mr. Chair, and thank you for the witnesses for your testimony today. Witness 1, do I have permission to call you by your first name that you used? Is that okay? Thank you. Jane, what you've done today is very courageous because people don't know this is happening. They have no idea. And I believe that halfway to beating this is obviously we have to do legislation and implement change, but people don't believe parents traffic their children. People don't believe that children are used as sexual tools online daily, as you've testified here today. They don't know because they don't want to believe that humanity is that horrific. And I want to tell you thank you, because we can't fix anything if we don't acknowledge what has actually happened. So thank you for that. A couple of things I want to point out. My colleague, the big thing we're trying to sort out here is the best recommendation so that we have implementation as soon as possible to protect children online. Sextortion, we've had witness testimony. Children are taking their lives. Jane, you're traumatized for the rest of your life. Your child is traumatized for the rest of her life. The impact on the community is significant. But right now, the way that C63 is written, it is calling on, and I'll use the language from it, a Digital Safety Commission of Canada, the Digital Safety Office of Canada, the position of the Digital Safety Ombudsperson, and the mandate for the Commission and Ombudsperson to follow. This is another arm of not having action instantly. And to my colleague, my Liberal colleague's point of immediate takedown of the image, you're not going to have that with C63 because you need a regulated body to be put in place, which could take years. What we're saying is in 412, we would implement this instantly through the actual social media platform. So a judge would have the capacity instantly to say, this is the person who has the image, release their name, and charge them. And the duty of care then falls on the social media platforms to be implementing age verification, which we know they can do through algorithms. The issue we're having with C63 is that the same issue we've seen in other regulating bodies, the action doesn't come with the intention. And the example I will give you is we have an ombudsperson in this country for victims. They've seen an increase of 477%. Nothing happens after the victims go to the ombudsman. Right? There's no action tied to it. So my question to you, Jane, would be, would you like to see a bill like C412 that implements instant action on the social media platforms and the judges to be able to ensure that those names are released so that there actual is takedown, not just intention of takedown?
So first, what I'm going to say is I'm not familiar with the bill that you just spoke about, but my concern is what's in Bill C63 is I see that adding protection moving forward for my child and the other children.
I appreciate you don't know what that bill is, so that's totally fair, and I'm happy to share that with you. I guess the concern is, again, if I was to tell you that in C-63, there still is this years down the road. So what I'm saying is we all want the same thing. We want protection of children today, but if you implement a regulating body and you don't have duty of care to the social media platforms, then it's not instant. Because the regulating body then has to have a meeting with a meeting with a meeting. Do you see what I'm saying? It's not direct to the person. Does that make sense?
I am trusting those that are in charge of Bill C-63 with what they're doing for the protection of all children in Canada.
Okay, I appreciate that. And I think, obviously, I can't stress enough that we absolutely want the protection of children. And again, I guess what I would put forward to you is if there was an option between going directly to the social media platform, I guess I will use you as an example. Right now, why are the images not removed of your child?
Because it's not mandated. Nobody has to remove them.
So
they're not told that they have to. There's no consequences.
Exactly. So with C-63, you would still have to go through a person, a regulating body. So let's say it's an ombudsman. Then that ombudsman would then have to go to have a meeting with the regulating body. Then they would have to go to the social media platform. What we're saying is instead of having that in between, you get to go right to a judge, and the judge says, okay, this is the person, because there's a duty of care for the social media platform to remove that image instantly.
Thank
I
you.
hear what you're saying, but I'm trusting the process. As a parent, I'm trusting the process.
Thank you, witness number one. Moving on to Mr. Biddle, you have 5 minutes.
Thank you very much, Mr. Chair. And Jane, I'd like to echo what my colleagues have said. The courage that you've shown to come forward is absolutely incredible, and your determination to not only protect your own daughter but other children is commendable. So thank you. I really didn't want to be getting into this because hearing from Carol Todd last meeting, she expressed concern that victims were being asked these technical legal questions, and I don't want to get into that. But I was wondering if you could comment, because you talked about your experience with police and the current process, and there was no help available. I was wondering if you could talk about what would it mean. I know some people will dismiss it as a bureaucracy, but to have a digital safety commission that could act for victims, I was wondering if you could speak for that, to have a voice, if that would be beneficial.
Sorry, were you directing your question towards me?
I was, thank you.
Okay. Yeah, you're correct. There really wasn't much help in the very beginning. I didn't really hear your full question. I didn't realize that you were directing it.
No, that's okay.
I
I can rephrase it, because the alternative that's being suggested is that victims are required to take it to a court and take it to a judge, which is, I think, well-meaning, but can also take time. I was wondering if you could speak about, in your mind, having someone like a digital safety commissioner act on your behalf versus your own requirement of having to take that on your own to a judge or to a court, and how you would see that.
Yeah, I'm totally all for that. I like to focus on the platforms themselves. Those people should be, like responsible for what content they're sharing. If they had some responsibility, then they wouldn't be allowed to continue to exploit my child.
You're absolutely right. And again, thank you for bringing this forward and speaking up, because I can tell you, dealing with, and I think Mr. Julian can agree with me, dealing with large tech companies has not been easy, and they've fought regulation along the way, but there are consequences and there are victims, and there's a requirement for government to act. And I think even with there's some disagreement around this table on what that looks like, I think there is unanimity in acting to protect our kids. So I guess I'll turn to Madame McNichol. You spoke with respect to the protection of privacy versus the protection of freedom of speech, and I was wondering if you can comment with respect to Part 1 of the legislation and its protection of privacy for the victims of these images, and the challenge of managing freedom of expression versus the protection of privacy and the rights of the individuals who are exploited by the internet.
Merci pour votre question.
Thank you for the question. From the outset, I would say this. There are specific statutory duties that are put forward in Part 1, and that would allow for the elimination of content that is harmful. For example, content that re-victimizes or sexualizes children, and intimate material that is shared without consent. So that is a new important development, I think. Now, that being said, there are issues with respect to privacy in Part 1, and that is why one of our recommendations is to clarify that the duties of operators and of the Commission and other bodies, regulatory bodies, must respect privacy, whether that be of the users and the operators, or the operators. And I'll explain. We know that operators have access to private information of the users. And there's also federal legislation that covers things like the collection of information, the collection of personal information. But those obligations should be specifically referred to, because that could entail, if they're not, that could entail consequences for operators.
Monsieur Fortin, to 2 minutes et demi.
Mr. Fortin, you have 2.5 minutes. Thank you, Chair. I'd like to come back to Ms. Claveau, or another representative from the bar, who could speak about life imprisonment. Now, I understand that the bar feels that this is very high. This is a huge punishment for a whole series of offenses. And I am also concerned. But my specific question is this. If we want this to be serious, if we want to be able to identify very serious offenses, would there be a way? I know you said that we'd have to look at the sentences more specifically, but could there be a provision that would say, in some cases, for example, that would be defined, of course, the sentence will be, the maximum will be the double, would be the double of a specific sentence. I'm just wondering if we need to go offense by offense, or if we can set levels. Well, thank you very much. I would refer you to page 8 of our brief. And we do propose a similar suggestion. We suggest that specific penalties, or sentences rather, that exist could be used, and they could be either doubled or increased depending on the offense. Yes, we looked at a provision that already exists, for example, violence against an intimate partner. So depending on what motivated this, if it's motivated by hatred, for example, the maximum sentence would be increased according to a table. For example, a usual sentence of 2 years would be doubled, could be tripled, etc. So these calculations aren't necessarily as simple as that, But what it does mean is that it follows the logic of the criminal code. Well, thank you, Maître Legrand. I don't want to interrupt you, but I only have a few seconds left. And what I want to understand is that simply saying something should be the double or a certain level, that's not a good idea. No, because, for example, when sentences are at a certain level, for example, 14 years, then you have a right to other procedures. So there's already a table that outlines this and that sets limits for various offenses. Thank you, Maître Legrand-Allary, and I think my time is up. Chair?
Mr. Julian, 2.5 minutes.
Merci beaucoup.
Thank you. Ms. Claveau and Ms. Bussière-McNichol, I'd like to come back to you. I'll start with Ms. Claveau. You referred to Section 13 of the Human Rights Act, and the minister, or rather the parts of the Human Rights Act. And the minister has already agreed to separate these. But one other point that was raised is that the Commission already doesn't have enough resources to do its work. And if Section 13 were restored, it would be very difficult to implement the process. Do you have the same concern? So I'm referring to restoring Section 13 and the lack of resources for a Human Rights Commission. That makes it difficult for the Commission to do its work. Yes, that is a concern. And it's a concern that we share. So along the same lines, if we look at the issue of digital security, well, there aren't enough resources there either, are there? That might be a concern. And we might find ourselves in a situation like, for example, the family of Jane, that would not receive a fast enough and strong enough response because of a lack of resources. Well, I would say from the perspective of the bar, we need to make sure that all the resources necessary are in place in order to be able to apply all sections, new or old, of the bill. So, of course, it's very important to have all the resources required. Thank you very much. And also, put the same question to Ms. Bussière-McNichol. So the question of resources for the Human Rights Commission and resources for this new body. Thank you for the question. With respect to the Human Rights Commission, you're right, and we have included this in our written submissions. It's a fact that they are already behind and that they are lacking resources. So it's very hard to understand then how other offenses like hate speech could be added to their workload. So from a very pragmatic viewpoint, there are issues. And we also have issues with asking tribunals to be responsible for another type of offense without the necessary resources. I don't necessarily have a comment about the other part to your question. If there's a new regulator or a new body, obviously they have to be funded adequately.
Appreciate your time and attention, and we'll suspend for 2 minutes. Thanks. Je souhaite maintenant acquiert. I now like to welcome the panel, the witnesses for the second panel, recognizing Emily Laidlaw from the University of Calgary, from the Collective Rights Quebec, Etienne Alexis Boucher, and from Open Media, Matthew Hatfield. Members, all these witnesses appearing by video conference have been tested. They all qualify. And with that being said, I'd like to turn matters over to the witnesses for your opening statements, and we'll start with you, Ms. Laidlaw. 5 minutes.
Thank you for the invitation to appear before you. My name's Emily Laidlaw. I'm a Canada Research Chair and Associate Professor of Law at the University of Calgary. At the last committee meeting and earlier today, you heard horrific stories bringing home the harms this legislation aims to address. With my time, I'd like to focus on the legal structure for achieving these goals, why law is needed, why Part 1 of Bill C-63 is structured the way it is, and what amendments are needed. My area of expertise is technology law and human rights, specifically platform regulation, freedom of expression, and privacy. I have spent my career examining how best to write these kinds of laws. I will make 3 points with my time. First, why do we need a law in the first place? When the internet was commercialized in the 1990s, tech companies became powerful arbiters of expression. They set the rules and how to enforce them. Their power has only grown over time. Social media are essentially data and advertising businesses, and now AI businesses. How they deliver that to consumers, how they design their products and services can directly cause harm. For example, how they design their algorithms makes decisions about our mental health, pushing content encouraging self-harm and hate. They use persuasive techniques to nudge addictive behaviors, such as with endless scrolling, rewards, and constant notifications. Thus far in Canada, we have largely relied on corporate self-governance. The EU, UK, US passed legislation decades ago. Many are on their second-generation versions of these laws, and a network of regulators is working together to create global coherence. Meanwhile, Canada has never passed a comprehensive law in this space. The law that does apply is piecemeal, mainly a bit of defamation, privacy, and competition law, circling important dimensions of the problem, but not dealing with it directly. So where does that leave us in Canada? Part 1 of Bill C-63 is the product of years of consultation to which I contributed. In my view, with amendments, it is the best legal structure to address online harms. And that brings me to my second point. This legislation impacts the right to freedom of expression. Our expert panel spent considerable time on how best to protect freedom of expression, and the graduated approach we recommended is reflected in this bill. So there's 3 levels to this graduated approach. First, the greatest interference with freedom of expression is content removal, and the bill only requests that for 2 types of content that are the worst of the worst, the stuff that we all agree should be taken down: child sexual abuse material and non-consensual disclosure of intimate images, both of which are crimes. At the next level is a special duty to protect children, recognizing their unique vulnerability. The duty requires that social media integrate safety by design into their products and services. And the third, at the foundation, is that social media have a duty to act responsibly. This does not require content removal. It requires that social media mitigate the risks of exposure to harmful content. In my view, the bill aligns with global standards because it's focused on systemic risks of harm and takes a risk mitigation approach coupled with transparency obligations. Third, I am not here to advocate that the bill is passed as is. The bill is not perfect. It should be carefully studied and amended. There are also other parts of the bill that don't necessarily need to be amended, but entail hard choices that should be debated. So to be debated, the scope of the bill, what harms are included and not, what social media are included based on size or type, the regulatory structure, new versus existing body, what powers it should have, what should be included in the legislation versus left to be developed later in codes of practice or regulations. There are, however, amendments that I do think are crucial, and I'll close with this list. And I have 3. 1, the duty to act responsibly should also include a duty to have due regard for fundamental rights and how companies mitigate risk. Otherwise, social media might implement sloppy solutions in the name of safety that disproportionately impact rights. This type of provision is in the EU and UK legislation. 2, the duty to act responsibly and duty to protect children should clearly cover algorithmic accountability and transparency. I think it's loosely covered in the current bill, but it should be fleshed out and made explicit. And 3, the child protection section should be reframed as the best interests of the child. In addition, the definitions of harmful content for children should be amended. There are 2 main amendments here. One is that content that induces a child to harm themselves should be narrowly scoped so that children exploring their identity are not accidentally captured. And 2, addictive design features should be added to the list. Thank you for your time, and I look forward to our discussion.
Thank you, Ms. Laidlaw. Turning now to Monsieur Boucher, 2 à 5 minutes.
You have 5 minutes. Thank you, and good evening to all committee members and parliamentarians. And thank you very much for giving me an opportunity to speak to you this evening on the pre-study of Bill C-63, which is about online hate. Now, I was supposed to be accompanied by the other member of our group called Mr. François Côté, but he cannot be here because of the brand of his headset. In any case, what I would like to say is that we are an NGO, and we feel that we are an actor of social transformation. We are active throughout Quebec, and our mission is to defend collective rights throughout Quebec. Especially with respect to linguistic and constitutional rights. We have a nonpartisan approach, and we intervene in many different ways. For example, education, social engagement, legal and political action. Now, I've given you a brief portrait of who we are, but what I would like to talk to you about today, is about the Quebec consensus on some issues, on 2 levels, actually. The first one is one that we have already acted on and engaged in. And we have been able to listen to people who have been affected by online harm. And Quebec itself actually has decided to act in this area. The Legislative Assembly adopted measures. Quebec doesn't necessarily have any powers with respect to the criminal code, but it did adopt measures to prevent, for example, sharing of intimate images, for example. So there is a Quebec consensus. And because the federal government was not looking at this issue, it was addressed through the Legislative Assembly. I would also like to say that these measures were adopted unanimously. And there is a consensus, or was a consensus, on sections 319.3b and 319.3.1b. that states that nobody can be found guilty of voluntarily inciting hate if they were expressing an opinion on a religious subject or an opinion on a religious text. We feel that in Canada, it shouldn't be a crime to express oneself. And in Canada, our representatives are elected democratically. We are in the 21st century, and freedom of conscience is important. There is freedom of opinion, freedom of political opinion, but there are restrictions. For example, when you're a professor, you can't necessarily express your opinions. For example, you can't express political opinions. So there are various constraints on fundamental rights that are justifiable. And now we're talking about a crime that may not be one. When we're talking about a freedom of religion, we feel that that's not acceptable. And we call upon parliamentarians to speak with the Minister of Justice of Quebec because they represent many, many Quebecers. And there is this consensus on freedom of religion, and it's unacceptable that there be hate speech that targets religion, though. There have been some very concrete examples. We've seen what has happened when there are exceptions. For example, when people publicly, in front of hundreds of thousands of people who attend events or who view social media posts, where there's a call, for example, where, for genocide of people of a certain faith. And it's very difficult to start any criminal proceedings against some of these individuals. We don't feel that's acceptable. And I would say that that's a consensus within Quebec. It's also the consensus of many secular groups. Thank you, Mr. Boucher.
May have additional time if the members decide to give you additional time, but your time is up. So now we're going to move on to Mr. Hatfield. You have 5 minutes, sir.
Good evening. I'm Matt Hatfield, and I'm the Executive Director of Open Media, a nonpartisan grassroots community of over 250,000 people in Canada who work for an open, affordable, and surveillance-free internet. I'm joining you from the unceded territory of the Stolo, Tsleil-Waututh, Squamish, and Musqueam nations. It's a pretty remarkable thing to be here today to talk about the Online Harms Bill. When Canadians first got a look at what this bill might look like as a white paper back in 2021, we didn't much like what we saw. Open Media called it a blueprint for making Canada's internet one of the most censored and surveilled in the democratic world, and we were far from alone in being concerned. For once, our government listened. The rush to legislate stopped. National consultations were organized across the country on how to get regulation right, with a wide range of stakeholders and experts on harms in speech. And the result, Part 1 of Bill 663, is an enormous night and day improvement. Simple-minded, punitive approaches that would do more harm than good are gone, and nuances and distinctions made throughout show real sophistication about how the internet works and how different harms should be managed. Packaging Part 1, the Online Harms Act itself, with changes to the Criminal Code and Human Rights Act that were proposed alongside it, badly obscured that good work. That's why, alongside our peers, we called for these parts to be separated, and why we warmly welcome the government's decision to separate those parts out and focus here on Parts 1 and 4. Open Media has said for years that Canadians do not have to sacrifice our fundamental freedoms to make very meaningful improvements to our online safety. The refocused Bill C-63 is the proof. Instead of trying to solve everything that's unpleasant on the internet at once, Bill C-63 focuses on 7 types of already illegal content in Canada, and treats the worst and most easily identifiable content, child abuse material and adult material shared without consent, most severely. That's the right call. Instead of criminalizing platforms for the ugly actions of a small number of users, which would predictably make them wildly overcorrect and surveil and censor all of us, C-63 asks them to write their own assessments of the risks posed by these 7 types of content and document how they try to mitigate that risk. That's the right call again. It will put the vast engineering talent of platforms to work for the Canadian public, thinking creatively about ways to reduce these specific illegal harms. And it will make them explain what they are doing as they do it, so we can assess whether it makes sense and correct if not. But I want to be very clear. It is not the time to pass Bill C-63 and call it quits. Just the opposite. Because the parts that are now being separated raised so many concerns, there has not been nearly enough attention to refining Part 1. I know you'll be hearing from a range of legal and policy experts about concerns they have with parts of Part 1's wording and recommended fixes. I hope you will listen very carefully to all of them and pass many of the fixes they suggest to you. This is not the time to be a rubber stamp. The new Digital Safety Commission is granted extraordinary power to review, guide, and make binding decisions on how platforms moderate the public expression of Canadians in the online spaces we use the most. That's appropriate if and only if you make sure they carefully consider and minimize impacts on our freedom of expression and privacy. It isn't good enough for the Commission to think about our rights in its explicit decisions. A badly designed platform safety plan could reduce an online harm, but have a wildly disproportionate impact on our privacy or freedom of expression. You need to make sure platforms and the regulator make written assessments of the impact of their plans on our rights, and ensure any impact is small and proportionate to the harm mitigated. and Bill C-63's protection of private encrypted communication and against platforms surveilling their users needs to be strengthened further and made airtight. Open Media has a unique role in this discussion because we are both a rights-defending community that will always stand up for our fundamental freedoms, and also a community of consumer advocates who fight for common sense regulation that empowers us and improves our daily lives. If you do your work at this committee, you can make Bill C-63 a win on both these counts. Since 2021, members of our community have sent nearly 22,000 messages to government asking you to get online harms right. Taking your time to study Bill C-63 carefully and make appropriate fixes before passing this bill would fulfill years of our activism and could make our internet a better, healthier place for many years to come. Thank you, and I look forward to your questions.
Merci, Monsieur Hatfield. Oui, vous n'avez pas la berlue. J'ai remplacé Monsieur Brock.
Thank you, Mr. Hatfield. And don't worry, you're not imagining things. I just replaced Mr. Brock as the chair for a while. Thank you very much for your statements. And we're going to start with Mr. Giovanni for 6 minutes. Thank you.
For Mr. Hatfield, thank you for your presentation. I'm curious, given the very clear concerns you've expressed related to parts 2 and 3 of Bill C-63, why you're not more concerned about some of the parts of part 1, particularly those related to the Digital Safety Commission, the Digital Safety Office, the Digital Safety Ombudsperson, which would lay some of the bureaucratic groundwork that makes parts 2 and 3 possible. Are you concerned about those parts of part 1, or would you care to give us some specific concerns you have related to part 1 that we're focused on today?
Yeah, I don't think that parts 1 does require parts 2 and 3. I think we can fully separate these, and I think the government should fully separate these. I think in terms of concerns we have with part 1, yes, it's a huge amount of power we're putting into the hands of this regulator. We believe that it is important that Canada has a regulator here in the same way that we have a privacy regulator, we have a competition regulator. Digital safety is a complex and nuanced enough issue that having a source of government expertise helping make good decisions on it is helpful. But that doesn't mean that you should just hand a blank check to this regulator. You need to put some really careful assessments and required limits on that regulator before this bill leaves committee.
Would you care to elaborate on what some of those limitations would be from your point of view that would need to be considered?
The single greatest in our view is that its decisions need to have mandatory assessments of their impact around freedom of expression and privacy. Both the decisions directly made by the Commission, but also when they approve these safety plans, if they approve safety plans submitted by the platforms need to write down what they think the privacy and free expression impacts are. And the regulator needs to assess and determine that those are proportionate, with the opportunity, frankly, for a case to be taken against them, saying that perhaps those the plans were not proportionate, so that they make impactful decisions but within bounds.
Again, Mr. Hatfield, there are other bills on the table for consideration. For example, that would be more focused on updating existing laws and making it easier for the existing criminal justice system that we have to be responsive to victims and to hold platforms more accountable. Why do you, it sounds like, and correct me if I'm wrong, why do you prefer the creation of what I would consider to be new bureaucracy as opposed to the strengthening of the system that we currently have?
I think there's a lot to appreciate in Bill C-412. We do think that bill, if this bill does not pass, is worthy of study. But I think Bill C-63 will accomplish more over a longer period of time for Canadians than 412. I think 412 is a narrow, perhaps a too narrow bill. And when it comes to the harms that both of them treat, I think having a regulator involved is really beneficial. Now, if you look at privacy law, we don't just say, here's your privacy laws in paper, and here's a private right of action, go to it, our privacy is defended. We found it extraordinarily valuable to have a privacy commissioner who can assist Canadians in asserting their privacy rights. And our hope for this Digital Safety Commission is they will function similarly.
Yeah, Mr. Hatfield, what I would put forward to you is that you mentioned sort of the long-term effects of Part 1. I would put forward that those long-term effects are the very parts 2 and 3 that you're concerned about, which is why I do think a lot of Canadians who agree with a lot of the objectives that the government has expressed related to part 1 are concerned about the ripple effects of what that will mean down the road, especially when the current government has already stated its intentions with a part 2, a part 3, a part 4. I mean, they've already said there will be sequels. And if you are concerned about the sequels, maybe the original may be worth reconsidering. But I appreciate your contributions. Thank you. With the remainder of my time, do I have
1 minute and a half.
Okay, with the remainder of our time, Ms. Laidlaw, I'd like to come to you and just ask for you to elaborate a bit more on the amendments that you had referenced in your opening statement. Just if you'd like to give us a bit more detail and more context, I'd appreciate it.
Yes, thanks so much for that opportunity. What I think is critical, and this is building off of what Matt was just talking about, was there is always a risk of overcorrection if the focus is purely on harms, and that's why it's important that one of the key harms can be to freedom of expression and to privacy in particular. And so it's important for the companies to be filing digital safety plans that explain how they make decisions bespoke to their services, balancing out the scope of harms, but also thinking through a way of doing it that's most protective to privacy and freedom of expression. The Digital Safety Commission would have a duty to consider that, and what they do is just, it needs to also be on the company. I think that the child protection measures, the best interest of the child is protected under international law. And that could become, I think that it's the blueprint here. And so detailing specifically what it is about child protection that we're looking for when we talk about safety by design is incredibly important. And of course, algorithmic accountability. I can discuss this further with you, but I'm conscious of time.
Thank you.
Alors, on va passer à Madame Brière.
We're now going to move on to Ms. Brière for 6 minutes. Thank you, Chair. And it's a great pleasure to see you sitting in that seat. And I'd also like to greet Mr. Alexis Boucher, who comes from my region. And my questions will be for Ms. Emily and Matthew. Ms. Laidlaw, earlier it was pointed out that this bill is the fruit of many years of consultation. You were part of the process of that consultation process, so I'd like to know why this list of 7 types of harmful content was retained, and why you feel we're requiring of the operators that they act responsibly. In other words, what does that mean to act responsibly? Because obviously they have to be able to identify and mitigate types of harmful content, but I'd like to hear your opinion on that.
Thank you. Having had many discussions with other governments, the duty to act responsibly is generally the same as the duty of care in the UK or the due diligence and risk management obligations in Europe broadly. It's all about this sort of due diligence approach of companies at a systemic level. The duty to act responsibly came out of the Commission on Democratic Expression, and it's really practical. Their recommendation was we shouldn't use the language of duty of care. That's language from tort law. It might be confusing if this goes to court. We want this to be a standalone statutory duty where the duty is just set out in the legislation. And so duty to act responsibly captured that better. When it comes to the harms that are included, I think that is a point for debate. In discussions with colleagues, one that could be added to the list is the crime of identity fraud. That is a major issue, and I think it would be appropriate to include that. I think it's notable what's not on the list. A point that I've had multiple discussions about is the inclusion of mis and disinformation, which generally fall into the category of lawful but awful. That is included in the EU legislation the decision was not to include it in Canada because of, what I would take it as the problematic risks to freedom of expression, that it's will be biting off more than should be taken on for a regulator. One last point. We have to think in terms of what a regulator can take on practically. We know this will cost money. And so some of this, I think, is a discussion of what should we include practically that is the high risk issues that a regulator can investigate and make a difference of now. And I'll leave it there. Thank you.
Merci beaucoup.
Thank you. Do you think then that this list of 7 kinds of harmful content should be reviewed, redone? Am I to understand that?
I'm acknowledging that it's a point of debate, and I think that there could be some reasonable arguments either way. I am comfortable with proceeding with the list as is. I think the only one I would add would be potentially identity fraud, but I would not be moving far away from the list as it is, also considering what's in federal jurisdiction to address as well.
OK. Et merci. Et vous avez dit...
Thank you. You said in one of your publications, actually, that even though there is room for amendments, this bill does cover the essential of the matter.
Big things right. Est-ce que vous...
Do you still agree with that statement?
Yeah, 100%. I think that the biggest point of debate was how do you actually structure a body to address these issues that balance harms and freedom of expression. And this does this, and that is because of the years of consultations and because it will fit in with the other global regulators.
Depuis le début de l'étude, on a...
Since the beginning of the study, we've heard from parents, especially mothers, who have told us horrendous stories about what their children have experienced and leading sometimes even to suicide. Do you feel that Bill C-63 will be concretely able to reach the goals that we have set out?
Yes. The caveat is we're never going to rid the internet of harm, and it's never going to be a perfect piece of legislation. This is about making things better. This cannot happen with existing law and improving existing laws, and it cannot happen just through the courts, although the courts are an important process. This requires a regulator that can work with industry, that is more flexible, that can work with impacted community and civil society groups, and that has the power for quick content removal for that worst of the worst. This is an ongoing project, and so in the long term, I think this will make things better, but certainly not perfect.
En 10 secondes, Madame Brière.
10 more seconds, Ms. Brière.
Parce que déjà, les plateformes ont...
Platforms already have their own rules. Sometimes they don't even respect those. So will BC-63 help in enforcing some of those rules? Yes or no?
Yes, merci.
Yes, it's about minimum standards.
Merci. Maintenant, la parole.
Thank you. My honorable colleague now has the floor. That is, say myself. 6 minutes. So thank you very much. Thank you to all the witnesses, for having come here, Mr. Boucher, Ms. Laidlaw, Mr. Hatfield. Thank you very much. Your participation is precious to us. Now, I'd like to raise an issue with perhaps Ms. Laidlaw. Bill C-63 provides, in terms of hatred, the ability of someone who is afraid that someone will commit an offense, that person basically can go before a provincial court. So when they have a reasonable belief that someone is going to commit an offense, are you not worried, Ms. Laidlaw, that that is too vague and that it could lead to abuse?
I I do want to emphasize that my support of what should be a fast track for study is part one, and I fully support separating the bills. I think parts 2 and 3 are fundamentally different. With that in mind, the peace bond provisions, I defer significantly to criminal lawyers that are practicing, because my understanding is there's so many hoops to jump through to be able to obtain a peace bond that this isn't the easy win that one would think in going to court and chilling expression. That said, the prospect of it can have that chilling effect. And that's why I think much broader consultation is needed on that type of provision, because I also am not sure if it's already needed. If the fear is property crimes, you can get a peace bond for that as it exists right now. So I remain to be convinced that it is a tool that will be worthwhile.
Merci, Madame Laidlaw.
Thank you, Ms. Laidlaw. I would like to ask you the same question. What would you say on the issue of a reasonable fear of a crime being committed?
We're very seriously concerned by parts 2 and 3. If those were still included in the bill, our presentation and our recommendations would be quite different here. But our understanding is that we now have the opportunity to see only part 1 and 4 pass together, and that is what we're calling potentially supporting.
Merci, Mr. Hatfield.
Thank you, Mr. Hatfield. Mr. Boucher, has Droit Collectif Quebec looked at this issue, and do you have an opinion on this? Service will be interrupted because there is not a proper headset being worn by Mr. Boucher. With respect to Bill C-63, in terms of hatred in Part 2, the minister announced that they would sever that bill, and I agree with this. We asked for this, actually, from the Bloc Québécois. We feel that the parts should be separated out. So right now we're doing a pre-study of Bill C-63, the entire Bill C-63, so that's why I'm asking the question, even though I feel that we should be considering those two parts separately. But within those parts, it says that if someone has a reasonable fear of a hate crime being committed, they can go before the court. Do you feel this is reasonable, or do you fear that this opens the door to abuse? Service will be interrupted for the answer.
Est-ce que vous pouvez répondre, Maître Gouin?
Maître Côté n'a pas le micro de la Chambre des communes, le casque d'écoute de la Chambre.
Unfortunately, headsets can cause problems for interpreters when they have not been approved, and that's why we cannot, unfortunately, hear the answer, even though I would have loved to hear. Mr. Boucher, the interpreters have been told that Mr. Boucher is not wearing a proper headset either. Service will be interrupted.
Des experts ici qui ont témoigné à ce comité, il semble évident que ce serait une bonne idée.
Merci.
Thank you very much. Mr. Boucher, can you speak to us about the definition of hatred that is being proposed in Bill C-63? Perhaps you heard the first part of our committee today, where the Quebec Bar gave its opinion on the definition of hatred, and they referred us to a Supreme Court ruling. I'd like to know what you think about that definition of hatred and how it should be set out.
Les collègues du barreau semblaient dire qu'au fond, la Cour suprême avait quand même relativement bien balisé ce que pouvait être un discours haineux. Et à quelque part, je pense que
Service has been interrupted because there is not an approved headset being used.
Juste un instant, Monsieur Boucher, on n'a pas de...
I'm sorry, we do not have the interpretation. The interpreter would like to point out that they are not wearing approved headsets, so service will be interrupted for the answers.
Okay. Yeah.
Alors, Monsieur Boucher, je m'excuse.
Mr. Boucher, my apologies, but I've just learned that unfortunately you are not wearing an approved headset. And from what I understand, both of you received your headsets last May.
Oui, mais ça va. Mais
So just listen for a moment, please. Unfortunately, and I'm only learning this now, you cannot testify. Neither of you can, for the reasons that your headsets were purchased much earlier. And unfortunately, this is an error on the part of the House of Commons. These were headsets that were sent last spring. You were not given the most recent headsets. And I'm afraid that if you would like to, or rather, if you would like to come back, we could bring you back at a later date. On the other hand, what you could do is send us your answers in written form. And of course, those answers will be provided to all the committee members and will be taken into consideration. So once again, though, if you would like us to be able to hear you in person, then I myself will request that you are invited again with the appropriate headset. So our apologies on behalf of the committee. I apologize. And meanwhile, perhaps you could send us your comments, your written comments. There's no point in showing me the box, unfortunately, because I am not the technician. I'm not in a position to be able to assess your headset. And I'm afraid we do take the safety of interpreters very seriously. There have been injuries. I learned this throughout the pandemic. And we must make sure that our interpreters are protected in order to be able to do their work. So once again, our apologies. Please send us your written comments, and we will absolutely read them. Now, I had 1 minute left for my question. And I'm just going to take that minute right away. So my next question is for Ms. Laidlaw. Ms. Laidlaw. There's the issue of the definition of hatred. Oh, no, I'm sorry, perhaps you already answered that. No, I'll start over. So maximum sentences. In some cases, there could be life imprisonment. So if someone commits an offense and it's out of this hatred as defined, they could be subject to a sentence of life imprisonment. Do you feel that this is adequate? Should that be revised?
Oh, this should be revised. I think that the risk of life imprisonment for a speech crime is wholly disproportionate.
Merci, et je vous.
Thank you very much. I see Mr. Hatfield nodding. Thank you very much. And my time is up. We'll now go to Mr. Julian for 6 minutes. Thank you very much, Chair. And I absolutely agree with what you said about the interpreters. This is a very important decision that was made, and we have to protect interpreters at all times. That is really the very foundation of our parliamentary hearings. So sometimes it's unfortunate, but sometimes we do have to say no, and you did the right thing, the responsible thing.
To Ms. Laidlaw, and thank you very much for your presentation today. You talked about algorithm issues as well, and I wanted to come back to you on that issue. We have, as you know, before Parliament, Bill C-292, which is an act respecting transparency for online algorithms. To what extent do you think, in addition to Part 1 of the bill, we need to be looking at legislation or perhaps incorporating portions of that bill to assure that we actually have a situation where Canadians can see the transparency around algorithms, and in that way as well ensure greater safety?
Thank you for the question. I agree. I think that algorithmic accountability should be added to Bill C-63. Earlier when I spoke, I said, oh, well, it's loosely covered. but it requires a leap of faith, so we need more in the legislation because the duty to act responsibly leaves to the Digital Safety Commission to develop codes of practice and regulations. And so there is scope there for algorithmic transparency and algorithmic amplification to be covered, but I think it should be that kind of digital safety by design and the algorithmic accountability needs to be embedded in the legislation itself. The same goes for the children's provisions. It does cover algorithms when it comes to safety by design, but it's one very short provision. So I think if we take your bill and some of the provisions in that, and that becomes a blueprint to flesh out those parts of Bill C-63 in Part 1, I think that we'd be in a good position.
Thank you very much for that. I wanted to ask the same question to Mr. Hatfield. Mr. Hatfield, you mentioned that C-63 Part A accomplishes more than a bill that has been raised around this table, C-412. And so I think you've resolved that for us. It's very clear we should be putting the focus on C-63 Part A. But to what extent do you believe algorithm transparency is also important to achieve? And to what extent would you like to see some of the provisions of Bill C-292 incorporated into Bill 63A?
Yes, I think it would be healthy for C-63 to go a little bit further into looking into what algorithms are doing. From the framework of providing more transparency, giving researchers good access to study algorithms and determine how they're impacting the public. If MPs can agree on some language there and get it done and move on to the rest of the bill, I think that would be healthy. I wouldn't hinge the bill's future on it, but I think that's the appropriate approach.
Can I ask both of you then, what are the international examples that we need to be considering as we deal with the bill, the Part 1, to ensure that we get the best possible bill coming out of committee, but also one that does what needs to be done at this critical time? And I'll start with you, Ms. Laidlaw.
I recommend that the committee studies first the Digital Services Act. The one thing to keep in mind is these types of European legislation tend to be a lot shorter and leave a lot to later. I think that Bill C-63 is a little bit more fulsome, but especially for the algorithmic accountability, the way that it's been addressed there could be helpful here. The other to consider some aspects of it would be the UK's Online Safety Act, and we have drawn certain aspects from Australia's e-safety commissioner structure. I can't remember the name of the legislation at the moment, but those are the three that I would recommend that you look at.
And we can learn from all of that, and essentially, as we look at international examples, hopefully they'll look at what we put forward. We're hopefully raising a higher standard, not impacting on freedom of expression, but putting in place the protections that are so important. I'll go to you, Mr. Hatfield, with the same question. The international examples that we need to consider as we work through this bill to get the best possible result.
For the international examples, I just have to mirror what Ms. Laidlaw said. I think it is the DSA first, and then looking at what some of what our Commonwealth peers have done in Australia and the UK. I do think from the perspective of partisanship, in the UK, it was a Conservative government that moved through a bill that had some of the same parameters as Canada's bill, and I would encourage everyone to remember that. If we were simply stacking 412, no changes, and C-63, no changes, every part 2 and 3 included against each other, in that contest, Open Media would prefer 412. But I think the exciting opportunity you have here, given that we're looking at just 1 and 4 potentially, is to strengthen and pass a version of C-63, which I think of the Canadian examples provides the best overall protection.
And you've been very clear that you believe in terms of limiting the regulator, that we ensure that there's mandatory impacts on freedom of expression and privacy that is part and parcel of every decision that is made. On a scale of 1 to 10, how important is that to you? With 10 being...
It's necessary for the bill to function. We would have concerns if it weren't dealt with.
Monsieur Président, est-ce que vous voulez que je continue?
Mr. Chairman, do you want me to continue? Or, well, I would have loved it if you could have continued, Mr. Julian, but your time is up, and it actually ended 10 seconds ago. But thank you. I'd like to thank our witnesses. It is now 3 minutes to 6, and we have to wrap up at the very latest by 6. So I'd like to thank all our witnesses today and thank our colleagues around the table for this meeting, and we will see each other soon. Thank you.
Merci de protéger nos